For this next topic, we look at the public resolution of international disputes. Now, previously we mentioned that disputes arise in business, and one of the functions of the law is to resolve disputes. That's what the law does. Resolution of disputes is governed by the law. Now, we mentioned in the first part of the lecture that businesses increasingly choose private resolution of disputes, and the reason why is that public resolution of disputes, which is litigation, is very expensive, time-consuming, and complicated. Nevertheless, we have to talk a little bit about the public resolution of disputes. We have to talk about litigation. We're not going to go into it in any great detail because there could literally be a class, an entire class on the litigation of international disputes. So we're going to keep it to a minimum. I just want to focus on a couple of big points. Now, when we talk about litigation, we're talking about lawsuits. We're talking about a court setting. And litigation is really the final alternative for resolving a dispute. It's the last place you want to go as a business person. Now, litigation in the United States is very common and for the most part easily accessible, but that's not the case in much of the rest of the world. In the United States, we also have a completely different system. We have an adversarial system in which the judge is a neutral party while each side presents its best case to a judge or a jury who are both neutral. Well, in most of the rest of the world, the judge plays an active role in the proceedings. The judge can cross-examine witnesses. The judge can appoint his own investigators to determine the truth or falsity of any allegations. So one of the big differences in litigation elsewhere is the role of the judge. We've mentioned discovery several times. That's something else that is very different in the United States than it is elsewhere. I've said previously that in the United States, discovery is a long, involved process taking upwards of a year or more in which the parties attempt to discover the evidence that each side will offer at trial. Well, in most of the rest of the world, discovery is not that huge, it's not that large, does not play that large a role as it does in the United States. Now, we've talked about before that in any dispute, there's two big issues at stake, and the first of which is choice of forum. Where will the case be heard? And secondly, choice of law. What law is going to apply to the case? So as we go through this lecture, we're really going to focus on those two aspects, choice of forum and choice of law. Let's talk about choice of forum. Now, choice of forum has several sub-issues, and we'll start with jurisdiction. Now, you probably have heard this term before. Jurisdiction is something that you've heard in the news. You probably studied it in your introductory legal studies course. But you need to know what jurisdiction is. Jurisdiction is the power of a court to hear and decide a case. Jurisdiction is really the most powerful concept in the law. Remember, we talked about the law and how it has two aspects, that of right and remedy. Well, in order to take advantage of the remedy, one must be able to find a court that can assert proper jurisdiction. So jurisdiction is the most powerful concept, most important concept in the law. And to make it a little more complicated, there are actually two aspects to jurisdiction, and you'll need to know these. And the first is subject matter jurisdiction, and the second is personal jurisdiction. Subject matter jurisdiction and personal jurisdiction are two aspects of jurisdiction. However, both must be present in order for a court to have jurisdiction over a particular case. Both personal jurisdiction and subject matter jurisdiction both must be satisfied in order for a court to hear and decide a case. So let's start with subject matter jurisdiction. Now, a subject matter jurisdiction refers to the subject matter of the dispute. A court must have jurisdiction over the nature of the dispute at hand. So when we talk about subject matter jurisdiction, we're referring to the court's authority to hear a certain type of legal matter. Now, how do we know what legal matters a court can decide? Well, those matters are outlined when a court is created. When a state creates a court, that court is given authority to decide certain types of disputes. And from now on, that court can only hear disputes that are within its jurisdictional power. So what would be an example? For instance, a family law court. A number of states have family law courts. A family law court can only hear matters related to family law. Marriages, divorces, child support, those type of matters. Similarly, a probate court can only hear cases involving probate, estates, wills and estates. That's the only type of case that a probate court hears. Now, sometimes jurisdictional power is set out by the type of dispute. Other times, we simply provide a maximum dollar amount of a dispute. For instance, in Texas, a county court can hear disputes up to $100,000, any matter up to $100,000, but nothing above that. A district court in Texas can hear any dispute unless that dispute is subject to another court's exclusive jurisdiction. For instance, in Texas we have small claims courts, and those small claims courts are called Justice of the Peace courts. Now, Justice of the Peace courts are unique in that they have a very low dollar amount of jurisdictional dispute. Depending on the region, it can be $5,000 up to $10,000, the maximum amount at dispute. However, those same Justice of the Peace courts have the power also to hear landlord and tenant disputes involving eviction. And in fact, they are the only court that can hear an eviction case. So even if the eviction involves evicting a tenant out of a downtown high-rise and the amount of back rent is somewhere in the range of millions of dollars, that dispute has to be heard by the Justice of the Peace Court. So every court has a certain jurisdictional power. It is authorized to hear certain disputes. Those disputes can be outlined by topic, or they can be delineated by the amount in controversy. That's subject matter jurisdiction, and it must be present in order for a court to hear and decide a case. Now, the other type of jurisdiction is called personal jurisdiction. And personal jurisdiction says that a court has to have authority over the persons in the case. This type of jurisdiction is also referred to as in personam jurisdiction. So in personam jurisdiction says that a court can only hear matters over a certain type of person. No party can be required to appear before a court unless that court has personal jurisdiction over the party. You don't even have to appear if the court does not have personal jurisdiction over the party, because anything the court would render would be a nullity because it did not have jurisdiction over the party. So this is personal jurisdiction. How do we decide what parties that a court may have jurisdiction over? Well, in some cases, it's a simple matter of geography. If you are living in a certain region and a court has personal jurisdiction over the parties in that region, then the court will have personal jurisdiction over you. The question that arises, and especially in the international context, is what if you don't live in that region? When is it that a court can exercise jurisdiction over non-resident persons? Well, there's a test for that. And in order for a United States to exercise jurisdiction over in order for a United States court to exercise jurisdiction over a person, that person must have what we call minimum contacts with the state.